Hey guys, and welcome to today's video. Today we have a courtroom Karen who makes a few crucial mistakes that will ultimately lead to her spending a lot of unnecessary time in jail. First, she violated her probation by using prescription drugs that she didn't have a valid prescription for. Then she lied while under oath, also known as perjury. And finally, she made probably the worst mistake she could have made. But we're going to save that one for later. So, let's begin.
Hamburg is 2308F4044. And what are we doing on Miss Amberg? The admission or contested hearing today?
This is just her initial hearing.
Oh, okay.
We filed a motion to recall the warrant or set a hearing. We're going to put yourself in on that board. So we're definitely not ready to go an admission today, Judge. With that being said, I do think it would be helpful to take some testimony as you make a decision about her, release or going with custody.
Step one, are we waiving the reading of the rights and the allegations of the petition?
Yes, Judge.
We will waive those formalities. A denial of the allegation, set a revocation hearing for February the 17th. And then Ms. McCrite State requesting no bond and her taken into custody on the warrant today.
Yes, Your Honor.
And Ms. Murray, why would I not do that?
Judge, the reason you would not do that, there are a couple of reasons. So the allegation in this case is that she tested positive for hydrocodone, which she does have a prescription for. However, she also tested positive for oxycodone and those types of drugs, which she did not have a prescription for. Ms. Amberg has been on community correction since early winter of 2024, so almost a full 2 years now, with no violations or issues. She does have, medical issues and was treating with a doctor who she was talking about her pain, and that doctor was wanting to put her on a higher pain management regime than she felt comfortable with. And so she switched to a doctor, and between those she did self-medicate with a friend, and that's where we got that oxy on her drug test result. But she has gotten a hydrocodone prescription, so she doesn't have to self-medicate anymore. In addition to those medical issues that are going on with her, significant importance is her 10-month-old grandchild, who her daughter lost custody due to neglect, and Ms. Amberg was given custody of this 10-month-old baby. There were no other family members who stepped up. And Ms. Amberg has spoken with Iris Rubidoux, who said that if she is not in custody and does not have a warrant, that she is invited to come observe family recovery court tomorrow, and that they would welcome her to go into that program to help her maintain custody of the grandchild, which, other than what's going on here, is in the child's best interests rather than being in foster care. So that's the other issue that's going on. And I just think it's, although, she didn't have the hydrocodone prescription on the day of her test, she got it actually the next day. I think it is relevant that a doctor has determined that she is in medical need of that, has given her that prescription, which she has now. And so that's why we would ask you not to take her into.
The time to get a prescription is not after you ingest highly addictive substances on probation. It's before, but even at that, they are about to scrutinize that prescription, which seems to be written by Dr. Defendant and not a real doctor. Now, I don't want to knock her for having an opiate problem. I'm a disabled vet diagnosed with ankylosing spondylitis. And when I got out of the military, the doctors instantly prescribed me hydrocodones for the pain, with a warning that I'd probably be on these for the rest of my life. After about 2 months, I was like...
So, a couple of the issues here. Family Recovery Court piques my interest. The fact that she has a prescription now for all the things may mitigate the drug screen, but it doesn't completely vacate the fact that she may have been positive for substances not prescribed. One of my main concerns is the prescription she tendered that does spell milligrams wrong. Doesn't capitalize her last name or any of the words in her address. And if we are going to say that that is a valid prescription, then I would swear her in and she could testify to that. And if I give her the benefit of that today, I'm going to have Mr. Shaw or somebody from community correction dig a little deeper. And if that is fraudulent, then have her charged with perjury and, of course, contempt for making that statement under oath to the court today. So do we want to allege that that prescription signed by Christie somebody is a valid prescription for Combunox? Catherine.
Judge, I believe so. And there is also attached to that petition to revoke prescription. And you can see that C. Coomer was the prescribing doctor on this prescription that community corrections has. Even though this document has some typos on it, or some multiple typos, there is another document that accompanies it, which looks completely credible to me. And also, Ms. Amberg and I have discussed this, and she does maintain that this was a document that came from that.
Okay. And that could be just an untrained somebody else typing. So Ms. Amberg, before I make any kind of decision, I'm going to swear again. You solemnly swear or affirm under the penalty for perjury the testimony you're about to give is truth. Do you understand you do not have to answer a single question that I ask you today? You have the absolute right to remain.
That oath that she's taking is not taken lightly by the court. And perjury is a separate crime in itself. The best thing to do is just say nothing and let your lawyer do all the talking. And, oh yeah, don't lie to your lawyer either.
You need to speak up a little bit for us because we're recording, but the document I'm looking at, and Ms. Murray held it up, it says medical prescription form, patient name Christy Ambergy, and it has the directions in there. Is that from a doctor's office?
Yes, sir.
You did not print that up yourself, type it in, anything like that. None of your friends did that. It comes from a valid doctor's office. All right. Ms. McCright, you want to ask her any questions to marry her to that testimony today?
I mean, Judge, honestly, I would have to object just under the most basic foundation and authentication rules for admitting this.
Oh, sure, it wouldn't come in, but I'm putting her down that if she's lying today, she's going to prison for it. So, but it's not going to be admitted, certainly. More the testimony is important than anything else.
No, Judge, I mean, I think whatever the court chooses to ask her is fine.
Okay. And Ms. Murray's right. I did see C. Coomer was the prescriber for that one. No reason to put it on the record. That one and that one. I don't know if those are what was written in that one or not. Ms. Uhas, do you have a release of information for her? Or
No.
okay. So, Ms. Amberger, the thing I think that's going to make the most difference to me today is that you have the possibility of getting into family recovery court to work these things out. So I'm inclined, although I need to look up, I'm still looking at your criminal history, to withdraw the warrant to facilitate moving forward with that possibility. That's why. I was also looking at this, the timeliness of this, but it was filed because it was consecutive, I'm sure, to the F5. So I'm going to withdraw the warrant for your arrest today. And we've got a revocation hearing for, let's set that one out a little bit if we're talking about, actually, let's not. Let's leave it set for February the 17th. And in the meantime, Ms. Uhas is going to dig in and find out if we can verify where that document came from. So Ms. Uhas, she probably was prescribed whatever it says on that page, but I'd like to find out who handed that to her, who gave it to her to print out, or who put it in the system the way it is. And verify that that was legit at the time. If we come back on the 17th and we've got some information that that was legit and somebody who just can't spell very well, put that in the system, great. We'll move forward with trying to get into, well, wait a minute, I'm putting the cart before the horse because family recovery court's going to have to be some sort of an agreement from the state. So Ms. McCright, if she gets the thumbs up from down the way and we've got some documentation that says that prescription was valid, although the use of the substances may not have been, what would your position then be? And we've still got the kid involved.
Judge, I'm still going to be requesting a revocation, especially if this is not something that is verifiable.
Yeah, that for sure. Okay, I still think setting this out is fine. So the other issue, one of the other allegations is the issue with the grandchild and the daughter, and justification or no, the allegations here support a violation of the conditions of your, actually Ms. Murray sent something that says maybe they don't. So that's something to discuss later. February the 17th, we will withdraw the warrant for now. Ms. Uaz, if you'll dig into that and find out if that entry is legitimate from whatever doctor's office, I would appreciate that on the 17th.
Will you send her down to our office to sign a release of information so that they'll speak to us?
That's what I meant to do. Yes, ma'am. We'll do that also. So, Ms. Murray, an objection to her going down and signing an ROI so we can get all that information? All right, perfect. So we will show the warrant withdrawn and initially the hearing set for February 7th.
All right. So that's the end of her first hearing. According to her own statement, that was a valid prescription despite the inconsistencies. There's only one thing that could get in the way of her getting out of this scot-free, and that's the court bringing the doctor on to testify as to whether the prescription is true and accurate, which they do.
And Christy Amberg is 2308F4044. And Ms. Amberg is on. Can you see her?
Yes.
All right. So we need to talk about a couple things here. Ms. Coomer, or Dr. Coomer, I apologize. I'm going to swear you in. Would you raise your right hand for me? You solemnly swear or affirm under the penalty of perjury the testimony you're about to give is the truth.
Yes, sir.
All right, thank you, ma'am. And Ms. Amberg, you didn't need to do that, but I appreciate that anyway. All right, so we have Ms. Rowe. But Tiffany, you're not on Ambergy's case, are you? Or are you? I don't know, it's been a while.
Crystal is on for Miss Ambergy.
Would you have her log in for us, please? Cover a few things.
I'm
I
here.
believe she's logged in, but her camera doesn't work.
Oh, yeah, there's something going on with Zoom today, I guess. Okay, perfect. All right. So one of the issues we need to cover, and I'm going to put everything out there and let Ms. Murray, Ms. Ambergy make a couple decisions. We have Dr. Coomer on to talk about the one document that was very suspicious and was, I'm not even sure if it was the basis for it, but Ms. Ambergy also testified under oath that she did not create that document and that the doctor's office did. Where are we sticking with that as of today, or have you guys had a different discussion, Ms. Murray?
I don't believe that Ms. Ambergy wants to stand by that position today. Is that correct, Ms. Ambergy?
I'm sorry.
So, Ms. Ambergy, the question that I'm asking you today is, we discussed a medical prescription form that I'm looking at right now that had that did not capitalize your last name, didn't capitalize any of the proper names in the thing, and spelled the word milligrams wrong. At one point at our last hearing, I asked you under oath if that was something you got from the doctor or something you created, and you said you got that from the doctor's office. Are you wanting to stand by that, or do you want to recant that statement and make an admission that you falsified that document?
What did my attorney say?
I'll let her say it again.
Well, Ms. Ambergy, do you want to continue to stand by that, or do you want to recant the testimony from last week or at the last hearing?
I'm going to tell the truth.
Telling the truth is what you should have done after you raised your hand and swore under oath that what you were about to say was the truth. Now, it's a bit too late.
All right, let me go ahead and swear you in. I saw you raise your right hand, but I didn't hear anything. So do you solemnly swear or affirm under the penalty of perjury the testimony you're about to give is truth?
Yes, sir.
And did you, in fact, create that document that is labeled medical prescription form and it did not have your name capitalized and it spelled milligrams wrong? Did you create that document or have someone create it for you?
Yes, sir, I did. I was scared about the Percocet in my system, self-medicating. Was worried about my grandbaby being in foster care. Yes, sir, I did.
All right. So, Ms. Ambergy, for admitting today, I'm not going to sanction you for contempt for the 180 days that I normally would, that I had planned on if you had stuck by that and we had to have Dr. Coomer testify that it was, in fact, fraudulent. I am going to find that you are in direct contempt of court because I told you I was going to do that last time and gave you every opportunity to back out. So I'm going to sanction you with 150 days fully executed in the Clark County Jail. That's not good time credits, 150 actual calendar days. And then we'll talk about the sanction for a violation next. So Dr. Coomer, we don't need your testimony. Is there anything you feel compelled to say right now?
No, sir, Your Honor.
All right. Well, thank you very much for your time. We appreciate you. You can log off if you want. You can
Thank
stay if
you.
you want. Your call. All right. So then I appreciate your honesty, Ms. Ambergy. Now where are we here on this, Anna? Did we have an admission or are we just having a contested hearing?
Oh, well, I think we can overall admit, there was one portion of this, however, which I believe was incorrect, and that had to do with whether or not there was a violation of a no contact order between her daughter and the grandchild, which we do not agree with that, but we do agree overall that there has been a violation of the terms.
Fair. Ms. McCright, is the state content with an admission of the violation for the fraudulent, whatever we're going to call that, fraudulent document and the drug screen, and we leave alone the EPO, the protective order issue?
Judge, that's fine by me. I think that's sufficient, and it's not going to sway my recommendation to the court one way or the other. I think it's going to be the same, whether it's 1 or 2 violations.
Yeah, I agree. But it does preserve pretty much some kind of an argument down the hall if it ever becomes necessary.
I suppose so.
Today you have the right to a contested hearing. At that hearing, that's what we're here for today. We had everybody ready. At that hearing, you can cross-examine all the state's witnesses and evidence. If you were to be found in violation of the terms of your community correction placement, you would have a right to appeal that finding and appeal any sanction that comes from that finding. For that entire process, you have the right to a public defender representing you free of charge. Do you understand that if you admit today, you're giving up each and every one of those rights?
Yes, sir.
You've already sworn in. You want to do the factual basis suit and craft, or do you want me to just avoid the protective order parts?
If you could just avoid the protective order part, yes, please, Judge.
I can do that. So, Ms. Ambergy, is it true that you tested positive for hydrocodone, hydromorphone, oxycodone, oxymorphone on a urine screen administered on January the 15th of this year?
Yes, Your Honor.
Is it also true that at the time you did not have a valid prescription for at least one of those substances?
Yes, Your Honor.
Is it also true that you falsified a document to try to cover the fact that you did not have a prescription for at least one of those substances?
Yes, Your Honor.
All right, thank you, ma'am. Do you admit that by doing so, you violated the terms and conditions of your placement with community correction?
Now, that wasn't too hard, now was it? If you would have done that from the beginning, you may have only got a slap on the wrist, and maybe the court would have put you in a program to get you the help you needed so that you could function in society without the pills. Instead, they're about to sanction you and send you to jail for lying under oath.
Thank you, ma'am. I find you did in fact violate the terms of your placement. Your admission was freely and voluntarily given. There's a factual basis for it. Couple things. She has a right to be present for the sanction hearing. She could waive that, of course, and I could do that online. And I guess she needs to make that call.
Well, we are going to be back here on Friday.
Okay.
Judge. So if you want to just hold off on that, and then we could do that at the same time as the petition to revoke probation that was filed in her other case.
That sounds like a pretty smart move. Ms. McCright, any objection to setting the sanction hearing on this for Friday, February the 20th?
No objection to that, Your Honor. Please note the state's continued objection to her continued release.
All right, perfect. We will do that. All right, so Ms. Ambergy, I'm going to sanction you already. Well, I'll hold that off. I'll tell you right now, I'm going to sanction you for 150 days for the contempt, but we'll do that on Friday. Friday, we'll have the sanction hearing along with the other case, and I will not, well, is there already an outstanding warrant, or is that not our?
There is an outstanding. Yeah, so originally, I didn't realize that there were 2 cases,
Right.
and I filed an appearance on one and not the other, and we had the hearing and withdrew the warrant on the one, not realizing that there was a second warrant. And so we haven't actually had that case in front of you yet. I tried to get them put together and I wasn't able to.
I wasn't going to withdraw the warrant because we discovered more information about the fraudulent document. However, I don't necessarily want her getting picked up in a different jurisdiction and not being here on Friday. So I will withdraw the warrant over the state's objection on the other case. They're both still set for Friday. Of course, Ms. Amberg, if you are not here on Friday, then we reissue those warrants for FTA and yeah, that's about it. Okay, so I'm going to pull the warrant on the other case just to facilitate. No reason you couldn't be here on Friday morning, 9 a.m. Make sure you're here in person. It has to be in person, no Zoom on Friday. And that will be your sanction hearing on this case. And is the other one a placement violation too, or is that a new case?
It's a petition to revoke probation.
Okay.
And it's actually based on just having the new case that she's, so I think maybe it should have been possibly filed earlier, but didn't get filed now, so.
Okay.
Until now.
Easy enough. All right, so Ms. Amberger, I will see you Friday morning in the courtroom in person. I want to be absolutely clear. You cannot Zoom in for Friday morning.
Yes, sir.
All right. Thank you, ma'am. We'll show that withdrawn over the state's objection, and that is it. And that's it for you too, right? Yeah, that's all we got on the calendar. All right. Thank you, ma'am. All right.
Thank
Ms.
you.
All right, so 5-mon jail sanction for lying on the stand about something that could have been solved by telling the truth and asking for forgiveness. Not to mention, by lying on the stand, you've put the court in a position to not be so lenient when it comes to your probation violations. But then she made things even worse for herself by not showing up for her probation violation hearing.
Let's go ahead and start with Ms. Ambergy so we can cut Ms. Murray loose. Christy Ambergy is 2303F572, 2308F4044. I don't see Ms. Ambergy in the courtroom. Ms. Murray, any reason to expect she's running 5 minutes late?
No, Judge, she texted me this morning and let me know that she was vomiting and on and off awake and was likely headed to immediate care and was not going to be here today. So I would request a new date sometime next week.
We will issue that FTA warrant over your strong objection and let you know when we catch up.
Well, that sucks for Grandma. I mean, this literally could have been a small sanction, possibly without any jail sentence. Instead, she just kept making it worse and worse for herself. And now she could be facing not just the 5 months in jail for contempt, but also a much lengthier prison sentence for putting the court in a position where complete probation revocation is the only viable option. The bottom line is when you play stupid games, you win stupid prizes. And today, she's the real winner. So, if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. And thank you once again to Train Well for sponsoring this video. Check them out with the link in the description.